fact that he made this move was he figured I better make this move before I can't make it for any reason, which he means he's deeply distrustful. If you look at what he did right after they declared him not the winner, so the AP did, his first action was to change who was in charge of the Defense Department and to try to start to bring troops home now. So he properly attributes responsibility and accountability to what happened to those who have been fighting him for 4 years within the deepest parts of the deep state. And some people object to the term. It used to be a lefty term. It just means dual state in the apparatus of national security and law enforcement. And research dual state, that was a well-recognized political science principle for 140 years. This wasn't controversial until suddenly it was applied to people that were opposing Trump. But you don't have to be a QAnon believer to recognize that obvious reality. It's one of the problems with people who are critical of QAnon. They criticize things that are clearly true and actually give more credence to it than I think is sometimes warranted. But so I think that's part of why he did it, part of cleaning up deep state apparatus. I think he recognizes now one of his great mistakes that he regrets is firing Flynn, that Flynn could have protected him from a lot of these actors over the last 4 years. And I think that was he was sort of a symbolic, signifying point of it. Some people think it's because he's going to bring in. Oh, by the way, you're muted.
No. I think you can hear me now.
Oh yeah.
Okay. No. Well, I know that Cernovich was very critical of Trump for firing Flynn at the time. I think you were as well. Is it Laura Ingraham who? No, Ann Coulter. I think one of his diehard followers essentially turned on him, and I think the Flynn firing and not standing behind his friends turned them off. But no. So getting to the idea, a lot of people think now that Flynn is freed up, he can divulge information, or he can participate in this process, or they're gonna get some goods out of him. You're not as optimistic on that as other people.
He's been out of that for 4 years, really for about 6 or 7 years. So he's not really roped in. He was put under a lot of pressure to not have contact with any of his allies during the criminal case, because a lot of them were put under criminal investigation. People don't know that. And so, I mean, if Flynn the reason why they waited is what Flynn didn't realize this. He was identifying for them all the white hats within the entire national security apparatus by saying, here's what we're going to put on these positions. Here's who's going to be part of these committees. And they waited for him to do that before they took him out. Because then they put every single one of those people, including people with like Flynn, impeccable records, no questions, etc., suddenly under meaningful criminal investigation. Several of them reached out to me for representation if the case had moved forward. So that's how I know those details. I won't go into further detail, but that gives you the scope of it. So I think Trump underappreciated what was happening, now appreciates what happened. And regrets what decision he made there. And of course, part of that was Pence. It was Pence's people helped do it. Like, for example, in the election context, even left-wing legal scholars, they were saying this, by the way, back in after 2000. Like, one of my tricks for lawyers out there is find somewhere where the judge's politics would have been on your side of the aisle in the past on that issue. Go back and find it, and you'll find interesting rulings and interesting case law, interesting legal work. Look at all the work legal historians and law review types and professors did between 2000 and 2004. You'll find all these interesting articles about how the Electoral College has independent power to do whatever they want, which is constitutionally true. That in fact the vice president, as the president of the Senate, when he takes in the electoral votes, he can decide which votes he certifies and which votes he doesn't. Does anyone doubt that if Kamala Harris had that power, she would exercise it accordingly? The lieutenant governor of Pennsylvania was just bragging how he would do it in the context of the state legislature being able to take action. But it was Pence's people that undermined Flynn, and it was again part of the problem. And so there was too many turncoats around Trump, and they did a very good job of getting rid of the people that could have been Trump's key allies. I mean, is it a coincidence that Roger Stone, Steve Bannon, General Flynn, and Julian Assange all get criminally prosecuted?
And 2 years ago, I would have thought I might have called this a theory, and as opposed to analyzing it, it's just empirical observation now. We've been talking about it. We've been seeing the politicization of the prosecutorial process. you see who the system runs into the ground, who they go after tooth and nail, while they're literally letting other people out of jail, or no recommendations of anything but, public consternation. It's undeniable, and it makes you feel like you've taken the red pill, or what some people call the black pill. But it's amazing. It's what I discovered following the Flynn case. I discovered the degree to which the entire system is politicized to the point of weaponized, and it's disheartening.
No doubt. Now, and Flynn does have some rights to sue. It's very tough to sue the prosecutors or other people involved. But I think he has legal malpractice for conflict of interest representation to at least get back his fees against his prior firm. I hope he does that. And he might have some of the same claims that Carter Page has. Good
segue. So for anybody who doesn't know, Carter Page is suing Strzok, a bunch of people from the FBI for, I don't know what to call it. You'd call it misconduct, except it's sort of fraudulent, or it's not, what's the word I'm looking for? Prosecutorial abuse. It's basically civil damages for having ruined his life through misrepresentations before the court. And we don't need to get into the bulk of it. I'm probably going to do a breakdown of it. It goes over all the allegations, the fraudulent FISA warrants, the fact that they've made admissions after the fact that they did in fact ruin his life, that they did in fact unlawfully obtain FISA warrants to go after him when there was no basis, and he's suing for damages. The cynic in me says chances of success are zero. This is telling your story, not winning. Am I being too cynical now?
No, he has a high chance because he has direct statutory claims. So the hardest part of his claims would have been any defamation claim and any Bivens claim. Bivens is the constitutional right to sue federal officers for a federal civil rights violation, but you don't get your attorney's fees, and there are certain limits on damages, and there are certain immunities you have to overcome. But in the FISA context, if you violate FISA, you have any person who's been victimized by any agent or any federal official violating FISA has a private cause of action directly against them for damages. And it's an underappreciated component of FISA. Normally, of course, you never find out that they violated FISA and screwed you. Carter Page is a very rare example of someone who has. So I think it's Leslie McAdoo Gordon is the counsel who drafted the suit. John Pierce is somehow involved, who I'm not a fan of, but we'll skip all that. She's a fantastic lawyer, drafted a great suit. First, identified the FISA violations. If you violate FISA law, there's a private right cause of action, including attorney's fees, including damages. On top of that, if you violate certain FOIA or Privacy Act laws, so if the FOIA and the Privacy Act sort of work together to allow you to get information on yourself that the government has, very underutilized set of records. People will be able to use state sunshine laws like the Georgia Open Records Act to get a lot of these files sooner at some point concerning the election, as an example. But it also has a limitation. The Privacy Act does not allow you to put out information about someone that you have within your possession unless it comes within the confines of the law. It also gives you a right to sue when they do so. So these are unique situations where immunity is not a defense, where truth is not a defense. It's just, did you disclose the information or not? Did you violate FISA laws or not? Did they injure Carter Page or not? There's no doubt they did. So he has a very, very vibrant, very strong claim that hopefully will set up a great precedent for the future to deter these kind of behaviors down the road.
And answering Truman H.W.'s question, I had the same question. First of all, do they have insurance? Do they have immunity? Are they protected if they're acting within the context of their employment? What are their defenses going to be?
Generally, the government will have to pay the price. So the government usually it's government's coffers. Sometimes it comes from individual coffers, but usually in these kind of cases, it comes from government coffers. Now, sometimes the government is insured in respect to it, but federal government usually they write the check.
All right. And then why does that remind me of something that we talked about in another lawsuit? The government taking up their defense. So does the government take up their defense? Do they have to mandate their own counsel, or does the government just cover a condemnation?
The government usually defends them.
Okay. I got booted from the stream twice. I have no doubt that's happening. And brother, I'm not complaining. It's amazing, Robert. We have people enjoying a Sunday night listening to two lawyers talk about law. Never in a million years would I have thought about this. So so this is interesting. So you think he's got a decent case. Does it settle before it goes to discovery? Do they want to avoid discovery? Is there discovery? Are there any specific rules that we should know about for the lawsuit?
He has pretty broad discovery. So if he uses the case right, he's going to find out a lot of information, and he'll get past a motion to dismiss unless he gets a totally crazy judge that does something wacky. You can't rule that out in the District of Columbia, unfortunately. But he's got a great suit and great chance at real remedy. So I hope that happens.
Did they have a chance, or did they have an option to file in a different jurisdiction to get out of the craziness of DC, or no real option?
Probably not.
Okay. So that's very cool. Anyways, Carter Page, I'm gonna do a breakdown of the lawsuit because it's very interesting. I read it over the weekend, but again, en diagonale, as we say in French. Speaking of something I wanted to mention before I forget, the latches theory that we've been describing before. It's latches, Laches, and it's a French origin term. Lâche in French means lazy, or it means lazy or cowardice. And in this context, it's if you are lazy to avail yourself of your rights, you lose your rights. So we call it's latches in English, but I think technically it should be called lâche, but that would not.
And imagine that doctrine is being used by people who only sue when they are injured, when they had no reason to know that the certain law would injure them before the suit. When they know if they did file, they would have been dismissed before the suit. To call them lazy, the first time I heard it was when I was representing Ralph Nader when he was up against it and just filed when he had to. And I was like, this is absurd. So latches is what the court is doing. And you have to attack it like that. You have to say the one advantage of the Third Circuit's ruling is one issue I hope they do take up as part of that, or is the Supreme Court should clarify this nonsense. Quit doing this no standing before the election, latches after the election, mootness a month after the election. This is all nonsense. These are lazy excuses. Who's being latches are the judges. They're being lazy and acting out of cowardice.